Hi everyone, this is Steve Maggi from SMA Law Firm. We've been representing clients at U.S. embassies and consulates for over 16 years. It's part of our consular law practice. And so we're very happy to share some good news for you about the national interest exception and how it applies to E2 and L visa holders and applicants. So after about 5 months of being closed, the U.S. embassies and consulates are now open for emergency visa appointments, and they are giving priority to cases which clearly qualify as being in the national interest. In this case, the economic interest of the U.S. Those are called national interest exceptions, or NIEs. There are a few different kinds of scenarios that apply here, as these exceptions can help L1 and E2 visa holders currently who do not want to triangulate through a third country to enter the United States. So if you want to enter the US directly and you're residing in the UK, Ireland, Brazil, Iran, China, or any of the Schengen area countries, you can apply for the national interest exception to avoid having to come through a third country and quarantining for 2 weeks. This gives people a great advantage. Obviously, it's much more cost effective than traveling to a third country without being 100% sure that you will be allowed to enter the United States. These submissions must clearly meet the requirement criteria that are stipulated and enumerated on the websites for each of these embassies, and each embassy and consulate has its own email address. So what's important is to submit the case well, comprehensively, with one PDF that has all of the supporting documentation to clearly show that the U.S. will economically benefit from the granting of these exceptions to those applicants. For those individuals who have already submitted a consular process E2 visa application and are waiting for an interview, the good news is that not only have the embassies and consulates reactivated processing and interviews, so you should apply now if you're ready to apply, but also that the E2 automatically qualifies for the exception, because one of the requirements for E2 is that you show that the investment is substantial, and that infers or conveys to the consular officer that it will have a strong economic impact, which is essentially based on job creation. So once you get the E2 visa approved, you should get the exception at the same time. For those individuals with petitions approved by USCIS for L1A or L1B petitions, you were barred as of June 22nd until the end of the year from receiving your L1 visas. Now a new exception under the national interest exception allows you, as of August 12th, to apply for a national interest exception, which allows you to get an interview as well as being evaluated under the criteria for L1A or L1B, which is very extensive, and you must be sure that you are ready to prove that at your interview when you apply for your L1A or L1B visa. In order to see if you might qualify or if you have any questions, feel free to contact us at any time. It's very important that you work with an immigration specialist in consular law, which is very different than immigration law in the United States, in order to maximize your chances of success. Thanks so much for watching, and we'll talk to you very soon.